Hello, this is Attorney Brian Pendergraft with the Pendergraft firm, and I'm a landlord-tenant attorney that is licensed to practice law in both Maryland and in the District of Columbia. And the topic of today's video is how Maryland is handling the moratorium on evictions under the Federal CARES Act. So, the CARES Act is short for the Coronavirus Aid, Relief, and Economic Security Act. It does a lot more than impose a moratorium of evictions, but I am sticking to the evictions part. The moratorium is also a federal law, so it applies to all states. However, the Chief Judge of the District Court of Maryland has issued a communication explaining how Maryland is going to be handling it. So I think that this is good for, Maryland landlords and tenants to know. So what I have pulled up in front of you is the communication that was issued by the Chief Judge of the District Court of Maryland. So I found his communication regarding the CARES Act very helpful, and I will be at least covering it in part in today's video, and I guess adding my own additional commentary to it. But before I continue, this is a legal information, and this is not legal advice. So for legal advice, you can contact an attorney near you. So again, this is what I have put up in front of you is the judge's communication with a few, as you can see, that I've highlighted it because I think highlights make it easier for me to kind of stick to the points that stick to the points that I want to make it. I think it helps me clarify my thoughts better. So let's get into it. Starting with paragraph 1, the Federal Coronavirus Aid, Relief, and Economic Security Act, CARES Act, imposes a moratorium until July 25th, 2020. So that is the end date of this moratorium. But you'll see as we go along. But even after this moratorium ends, landlords are required to send a notice before filing for eviction. So we're going to. I think I'm skipping ahead a little bit, but I just don't want you to think that July 26th I can just go file a failure to pay rent action. So it's not quite like that. So until July 20th on the filing of summary actions. So here's my highlight here, as you can see. But in the judge's version, I think he clearly underlined filing in his version. So it may be difficult to see that in my version, but so I think he underlined filing to bring emphasis to the fact that that is what is prohibited: the filing of a summary actions. In other words, what's a summary action? That's a failure to pay rent action. But so what's being prohibited is filing failure to pay rent actions, but it does not necessarily prohibit filing, let's say, a warrant of restitution if you've already been granted let's say a failure to pay rent action, a judgment for failure to pay rent. And again, it's limited to summary action. So what is not a summary action is a tenant holding over action or a wrongful detainer action. To recover possession of covered property for non-payment of rent. Again, so what's being prohibited is filing for non-payment for let's get into the next sentence, for a covered property. So a covered property, as the next part defines what a covered property is. So this includes public housing, federally subsidized housing. So that's pretty clear and simple, but you see, my next part is I use different colors because I think that it requires a bit more a bit more commentary. So it covers both public housing and federally subsidized housing, and residential property that is subject to a federally backed mortgage. So that is actually means that a lot of landlords that are renting out a residential property that is subject to a federally backed mortgage, that this moratorium applies to them. And that is a lot of landlords. That is many of my small landlord clients. A lot of them have they may have a second property that's residential property, and they may have got a federally backed mortgage loan. Those landlords again, they are prohibited from filing for failure to pay rent under this action. Now what is not prohibited under this under this particular moratorium is filing for commercial property. So if you are let's say a commercial landlord's moratorium it is not applying to you. And also if so essentially I think that covered it actually. So let me go forward. So the moratorium also provides that a lessor of a covered property may not evict a tenant until after the moratorium expires, except on 30 days notice, which may not be given until after the moratorium period. So what that is saying is that even after the moratorium period, a landlord has to give they have to give a 30-day notice, or definitely should be in writing. Definitely to give a 30-day written notice. So you definitely want to get it in writing. You may want to, proof of mailing too. Anyway, so landlords and agents are all right. So we're on the paragraph 2. So landlords and agents are prohibited during the period of the moratorium to file failure to pay rent actions with respect to the identified covered properties. So again, if your property has been a covered property and you have filed a failure to pay rent action, you're not supposed to do that. You're prohibited from doing that. But the next sentence says, what landlords or their agent should do if they have filed any such actions in violation of the moratorium. They should notify the court in writing of such filings. So if you've been, I guess, just been filing your failure to pay rent cases in order to try to, let's say, get ahead of the rush on filing when the courts open back up. I know quite a few attorney friends, colleagues of mine have been doing that. So it's like, or perhaps landlords have been doing that as well, where it's like, all right, cool. So I'm going to file my failure to pay rent action now just so I can get ahead in line. Well, unfortunately, if you've done that after this moratorium was issued, then you're going to have to notify the court in writing that hey, I've I guess violated the act or whatever. You're gonna have to notify the court. So let's see, indicated, let's see. So, last sentence here. So, if landlords agents have filed failure to pay rent actions during the period of the moratorium and have indicated on the failure to pay rent form that the subject property is a government subsidized tenancy, the court will require evidence that the property is not subject to the CARES Act before proceeding. So, if it's a government subsidized tenancy, then the court will require additional evidence. So, if you have renting out that your so if you have a government subsidized tenancy and that is not subject to a federally backed mortgage, then or that is not subject to the CARES Act, I should say. That's probably a better way to say that. Not federally, not subject to the so scratch that part that I said about not subject to a federally a backed mortgage. I definitely bespoke right there. But if it's a government subsidized tenancy and it is a covered property, and it is not a covered property under this act, then you will be required to bring additional evidence to show the court. I guess the assumption is that it's if your property is government subsidized, then it is much more likely to be perhaps subject to being a covered property. So they want you to bring additional evidence to make sure that you can verify that it is not subject to the CARES Act. All right, so scrolling down, and there was one more thing that I wanted to cover in the that I wanted to cover here. As you can see, this part that I have highlighted. So we're going to skip down to that. So moratorium. During the 120-day period beginning on the date of enactment of this act, the lessor of a covered dwelling may not charge fees, penalties, or other charges to the tenant related to such non-payment of rent. So, in other words, it's saying that you cannot charge late fees. So, I think that's good for both landlords and tenants to know during this 120-day period. You are not able to charge late fees. So that is it. So again, I'm Brian Pendergraft with the Pendergraft firm. I hope you found this video informative and helpful. And if you have any questions or concerns, feel free to reach out to me. And if you would like assistance from a landlord-tenant attorney to perhaps take care of your filings in the future, do not hesitate to reach out to me. Thanks for watching.